many people are panicking at the moment. So you will probably see a lot of emails coming your way where people say, you are on our mailing list, but we want you to opt in again. We actually think this is not necessary.
Hey Hatchlings, welcome to the Motion Hatch podcast. I'm your host, Hayley Akins. Hey, nice to have you here. If this is the first time you're listening to the Motion Hatch podcast, this is a podcast where we talk about the business side of motion design and animation. And what that means is basically we talk about how to get clients, how much you should charge, what you can put in your contracts. We talk about laws that are coming up and how it might affect motion designers, which is what we're talking about today. So I brought Silvia back on, who was on a couple of episodes ago, where she was talking about what we need to include in our contracts and a bit about intellectual property for animators. So if you haven't listened to those, I do encourage you to go back and listen to those as well. So a quick disclaimer before we get into the show. This podcast is for general guidance only and discusses the legal position in the UK at the time of publication unless stated otherwise. You must take legal advice and not rely on the information provided in this podcast before taking action. We do not update our podcasts and therefore past podcasts may not reflect the current legal position. Now on today's show we're talking about the new law that's coming in called GDPR. GDPR is a new law in the EU on data protection and privacy for individuals within the European Union. But if you're in the US or anywhere else, please do carry on listening because it still applies to you if you have any customers, clients, or fans in the European Union or EAA countries as well. So I hope you enjoyed the episode. See you on the other side. Hey Silvia, thanks so much for coming on the show again.
Yeah, it's a pleasure to talk about the GDPR today.
Cool. Do you want to start by telling us what GDPR is?
So GDPR is short for General Data Protection Regulation. And this is a piece of EU law which will come into effect in the UK on the 25th of May. It will partly replace the Data Protection Act 1998, which is currently in force. And as the name says, it regulates data protection within the EU and the EEA area, including the UK. So we all have to comply with this regulation.
Cool. So as freelance motion designers, what are the key things that we need to consider?
So first of all, you need to consider if this regulation applies to you. It's very likely to apply if you keep, say, a mailing list, which includes personal data. And personal data, again, it's pretty straightforward. It's data that, if you have this data, you can identify individual people. It applies to any businesses or, individuals doing something within the EEA area. Or even if they're outside and have customers or clients in the UK or in the EEA area, then this applies to these businesses and also individuals that trade. And trading means in this context, it basically means that they're offering goods and services, but it could also be free, the services. So you don't need to pay money for it. It could fall under this kind of trade. So, and personal data is basically data which you hold and have at one point collected from people, and you can identify people. So that includes the first name and the surname, addresses of individuals, email addresses that show the first name and the surname. For example, my work email address is a personal data because it shows, my first name and my second name. It could be financial information. If you have to invoice somebody personally, an individual, then you have to collect their bank details for the invoice to process. In terms of motion designers, I assume that everybody has maybe a client list. And you have to really consider for what purpose you control and process this personal data. So the Act says, there are 5 principles in the Act. And it says you have to process data lawfully, fairly, and in a transparent manner. So lawfully and fairly is already in the Data Protection Act, and transparent is new, and that requires you to be very transparent of what you do with the data. So, for example, I have already mentioned that you might process data for invoicing. You might process data for the sake of keeping a mailing list and informing, potential clients about what you're doing, about your latest project, in order basically to promote yourself. Some of you might not only hold client data, which includes personal data, like personalized work email addresses, that I might also hold some data for maybe you have some sort of goods to sell on your website. Maybe motion designers like illustrators might sell some characters design or posters or merchandising, whatever, on website as a side income. So you're dealing there with the public. So in this respect, this is marketing, and this requires you also to consider the GDPR and also in conjunction with the e-privacy regulation, which is another piece of legislation which is already in force. And this e-privacy regulation regulates what you can do or you can't do when you process data for the sake of emailing, using emails to for marketing, using phone calls for marketing, or faxes for marketing. And that has also an influence on the So you need to kind of consider these 2 pieces of legislation for, whatever you do with your data. For example, the e-privacy regulation, it's actually called the Privacy and Electronic Communications Regulations, called PECCA. And this is, as I said, relevant for direct marketing via electronic communications. And it also regulates the cookie policy. So nothing has changed there. But obviously, what has changed is the GDPR and how we now deal with the data and what you can and cannot do. So let's maybe just go to an example. So first of all, what you should do is you should look at what kind of data that you have. So the GDPR regulates the use and what data you have that are personal data. And that includes this kind of data, which I mentioned before, personalized email addresses, financial information. It could also be, when you think of some systems like Google Analytics might know where persons are located, what kind of preferences they have when they browse the internet. This is all personal data and regulated by the new GDPR regulation. And on top of that, we have PECCA, which then regulates e-marketing. That only regulates e-marketing to individuals and sole traders. So if you e-market to companies, there are certain regulations, but they're not as strict as when you would like to market, send a promotional email to your clients that are mainly companies.
Yeah, so basically, it seems like there's kind of 2 different things that we should be considering. And one is you have clients who are businesses and maybe you have a mailing list, maybe you have them on like some sort of spreadsheet or something. And then there's some other people that might have to consider a few other things as well, when maybe they sort of have like an audience or a fan base and maybe they sell, like you were saying, maybe they sell some merchandise, like some posters or some designs on prints and things like that. So
exactly.
That's kind of almost two different things, because you've got like one is more public facing as well as the clients, and then some people might just have the clients. I just wanted to like clarify that.
Yeah, so they influence each other, so you can't think about data protection without one or the other. Yeah. So if we, for example, think about the GDPR, under the GDPR, which regulates what you can do with personal information, and that includes, and this we need to be very clear about, includes, for example, work email addresses. Yeah, although this kind of information is part of a company. Yeah, this person might be part of a company. It is still personal information, and therefore you need to consider GDPR. But under PECA, you, for example, could, in theory, send this person an email advertising your services, because you would email them in their capacity as a representative of the company. So let's start with the GDPR, because this is the wider remit and includes any personal information. So first of all, what you should do is you should see what kind of personal information you have, So looking for anything in your system of what you have at the moment, which could be personal information. And you should not neglect what you, for example, do on your website. So for example, you might have a website with a blog where people can leave comments. And these comments, when they leave comments, they might use anonymous as a username, but they might also give you their own name. And if they give you your own name, then you are controlling the data, because it will be probably on your server. It will be hosted, this kind of information, which is personal information, it's their name. And you might even find that when they leave comments, that you can gather some information about their opinions, about preferences, and so on. And this, again, is personal information. So if you run a blog where people can contribute and can, register or, leave comments with their name and then leave you an opinion, and this person is identifiable, this is personal data. So you should list that as personal data, what you have. So if they obviously leave a comment and you don't do anything else, all you have to do is, because you basically have the data, you don't do anything else with the data, then you just say, okay, I have that for the purpose of them allowing them to comment on my website. And you can assume that they have given you consent to do that. Yeah. So if you would list their data and start marketing to them, this is something you need to consider carefully, because, their data is there because they have voluntarily given you the data for the purpose of commenting on whatever you have written. You cannot automatically assume that they would like to receive your newsletter, because they haven't given you consent. And there are quite a few purposes for which you are allowed to kind of use this data. So you can, for example, say, okay, I use this data for the purpose of them leaving a comment, and they clearly have consented because that's what they have done. And the legitimate reason for you to have this data is, that they have given you consent. And then there are other people whom you might use their personal data for the purpose of sending them information through a newsletter. So you can say, okay, the reason why I'm doing it is either they have at one point subscribed to your newsletter, then you have explicit consent, Or they might have used your services and paid for it, and then you have some sort of implied consent. Or you can say, okay, they have shown interest, and the legitimate interest for me processing their data is a commercial interest because, they have shown interest, and keeping them informed is also beneficial to my business. And to do that, it might not harm their privacy or so. But you need to be quite careful when you do this. So you need to kind of think about the reasons why you are, controlling that data and for what purposes, and then think about, do you have legitimate reasons to do that? So consent is one reason for certain processing, and the e-privacy regulation comes into play. For certain processes, you need consent. So, for example, as I mentioned, emailing to individuals needs consent, unless you have already had dealings with them by having sold them any services or sold them, something, then you might justify that they might not have given you explicit consent, but they have given you, implied consent, or they have kind of what's at the moment is called soft opt-in, because they have shown interest. So you can justify that that's a legitimate reason to hold their data. But as I said, this kind of commercial interest is a legitimate interest, is quite flexible. But if you don't have explicit consent, there is a 3-part test to it. If you hold data and then you would like to use legitimate interest for the reason to hold this data for this particular purpose. So first you need to think about, are you pursuing a legitimate interest? So think about, what's your legitimate interest? So is it something that benefits the business and sustains your business? Or is it, for example, you hold this data for, say, debt collection to process an order and so on? And then necessity, is the processing necessary for that purpose? So you can only hold personal data for a particular purpose if it's necessary to hold that data. For example, in order to send updates to people on your mailing list, you don't need postal addresses, you don't need their financial information and this kind of stuff. So you can only hold data that's necessary for that purpose, for which you want to use the data. And then you need to think about, do the individual's interests override your legitimate interests? So, for example, it would be over the top if they show interest in a voucher. So you have something, sign up to get, say, 15% discount, or you get a 15% off voucher if you send me your email address. And then somebody sends an email address to you, and clearly what they expect is a 15% discount voucher on their next order. It doesn't matter if they then order something or not. So the question is, can you use this email address to then follow up with an email making them aware that they have now the 15% voucher and the newest offers on your website, following it up basically with a marketing email. So this is the question, because you have consent to send them the voucher or send them some sort of, voucher. But do you also have some sort of legitimate interest, if you don't have explicit content, to also send them an email follow-up? And this is, a kind of the question. So you would need to think about this 3-part test. So you don't have explicit consent. So this is out of the question. you might obviously have a commercial interest because you want to promote your business. So this might be a legitimate interest. And is the processing necessary for that purpose? You could say, yes, I need the email address for that purpose. So otherwise I can't do it. And then the balancing is a bit tricky because do the individual's interest override the legitimate interest? So if you yourself think that the individual will probably, because they have already shown interest in buying something, otherwise they wouldn't have requested, the voucher. They might have given you an indication that they expect maybe a follow-up marketing email from you. So under the GDPR, you could maybe process their data in this way, stating commercial interest, And maybe you can also justify it and say, okay, that doesn't really impact on their individual interest because they might expect that when they leave me, their email address and they have clearly shown interest in my products or service, that they expect me to maybe send just a reminder of what they could buy from me with that voucher. Yeah. Okay. So if it's related maybe to the voucher, okay, you could maybe do that. Under PECA, this obviously is direct marketing via email. So falls under PECA if this is an individual. And if that falls under PECA, you would need explicit consent. Unless they already have bought something from you. This is a so-called soft opt-in. So in this case, I would probably err on the side of caution and say, okay, I'm not quite sure. Maybe, it's better to have explicit consent before I start sending them marketing emails.
So it comes under the PECA law because it is to the public, like to a consumer rather than to a client.
Yes, exactly. That would be, yes, exactly. But let's go back to your client list because I suppose it's the exception that you send emails to, the general public. It's probably that if you have a mailing list, a mailing list where you send out a newsletter, unless it includes individuals or sole traders, you probably don't have to think about PECA. But if your mailing list includes, individuals and sole traders to which you send the email, then you need to consider PECA. Yeah. If not, then you only need to consider GDPR. So let's talk about GDPR when you have a mailing list that is solely going to clients, and we assume these clients are all companies and not sole traders. So companies in the sense that they are registered companies in some way or another, because most of your clients are probably registered companies and not freelance individuals. So in this case, what you probably hold on data is financial data because you need to invoice them, but you might know that the financial data is probably not related to an individual, but to a company. So that wouldn't be personal data. The only personal data you would hold is probably a first name and a name and an email address and a job title from the person you're dealing with at the company, say an account manager or something, or a creative director or whatever, you have. So this is personal data and falls under GDPR. And for that, you need to kind of assess, what kind of data you have, for what purpose, and then think about the legitimate interest or the legitimate reasons, the legal basis for the processing of this data. Yeah. So, and that could be consent or legitimate interest, or it could be that you have some process, a contract and so. And then you think about how long you need to hold the data and so on. So in a way, what most people at the moment are concerned, what impact has it on our future marketing? Yeah. So, and the impact is actually quite simple. You can actually continue as before. Also, you need to think about, where does the data come from? Who is processing my data? What I'm doing with it? And also, how long do I hold the data? Is it necessary you shouldn't hold it longer than necessary. You should keep data up to date if you have personal data. And so you should basically start with an audit of your data and assess, what you have and so on. And you don't have to ask people if you're operating with a mailing list, you're operating, for quite a while. You don't have to ask people to opt in again, because otherwise you would probably lose half of your mailing list. You can assume that at one point either you got consent or they have shown some sort of interest in your business. And if you want to be, particularly transparent about what you're doing. So you have to make it clear, that they can opt out from receiving your mailing list. But if you are having your mailing list with, reputable providers, then you can assume that, unsubscribing is pretty easy. But what you should do is you should, at this point, then also update your privacy policy.
So I just wanted to jump in there. So basically, like as an example, so I have a mailing list.
Yes.
Which has like my clients on it. And some of them have added themselves through my website, but some of them are just clients that have either hired me or some of them that I've added manually that kind of have just been in touch about work, but maybe I haven't been free, but I've added them to this mailing list. Like, so does what you're saying apply to that, where I don't really have to do anything, just if I send them like a monthly newsletter or something, as long as it says, somewhere, because I use MailChimp, it says on the bottom, like you can unsubscribe at any time. Like, as long as it has that on there, you don't think that people need to do anything before the GDPR law comes in on the 25th?
No, I think the consent among, lawyers, because we are discussing it at the moment, what should we best advise our clients to do? So many people are panicking at the moment. So you will probably see a lot of emails coming your way where people say, you are on our mailing list, but now we want you to opt in again. Yeah. So we actually think this is not necessary. Especially this is not necessary when you're dealing with clients that are companies. Yeah. So you just have to make sure that there is a clear way, and they know that, to withdraw their consent, to kind of unsubscribe, from your list. And what you also should be aware is that under GDPR, you should keep your data up to date. Yeah. So you shouldn't operate with old, out of date data. But I know, for example, that MailChimp, once an email address is not valid anymore, that it will be thrown out, as far as I know. So the system tells you basically if an email has not gone through. So I have seen, for example, today I got a message from a very, international law firm, a very big law firm, and I have subscribed to their newsletter at one point because I went to one of their events. So got on their mailing list. And they haven't sent me an email to opt in again, which is interesting. So obviously they're of the same opinion as we are, that you don't have to opt in again if they haven't got explicit consent, because I didn't really give them explicit consent when I did that. But what they did is, and I think you don't need to do that because this is, they have particular systems in place, but this is, very good practice in a way. They sent me just, a link to my record. Yeah, they obviously have a record about what I've given them. So that was my name. So first name, surname, my job title, the company I work for, and my email address. And so they wanted me to confirm that the data they hold about me is still correct. And then they also wanted to confirm, my preferences of information, what kind of information I would like to receive from them. And at this point, I could have said, I don't want to receive any information from you. Yeah. So they let me tick some boxes of what kind of information I would be interested in. So this is very good practice in terms of marketing. Yeah, especially when you market to individuals. You don't need to get to this length. I think what's important is that you just be very open and make it easy for them to withdraw from your mailing list. But you do not have to send now out an email saying, can you now opt in again, to my whatever you have done in the past. I don't know where your data comes from, but please opt in again. Yeah. So you don't have to do that. Just give them an option to withdraw and unsubscribe. And the privacy policy, I think if you have a website, you should also have a privacy policy, especially now with GDPR, where you have to keep records of what you hold. You have to keep records also. You need to state where they come from, if you have received them from a third party or if you have received them directly. You should think about that and then state what you know about your data and be transparent and open about, where data comes from, where you transfer data to. For example, if you use MailChimp, then obviously MailChimp for that purpose is a data processor. So you are the data controller and they do something with the data for you. Yeah. So they are sending the mail out for you. So they process data on your behalf.
Yeah.
And therefore they are the processor. So you have to, state that in your policy, who is processing data, to whom for that purpose you transfer data, and for example also where data comes from, so where do you collect data from and so on. Yeah, for what purpose, what's your legal basis for processing data, and how long do you retain data. So this is basically what the data audit, and then you just state it in your privacy policy. It sounds simple. It is. It probably is simple, but it sounds, when you read about it, it sounds pretty complicated. But in a way, in simple words, this is what you should do.
Yeah. So on my sort of portfolio site, then I should kind of put on their little privacy policy saying that, I collect people's emails for my mailing list, which is for, to market my services and my business, and then stuff like that, people who use like Google Analytics, that kind of thing, because IP addresses I think are included too as like personal data.
Yes, it's kind of, I'm not sure what category of data, but yes, it's regarded as personal data. So Google Analytics is interesting because obviously Google Analytics is providing you with data. You have not collected the data. That data comes from Google Analytics because Google Analytics basically traces people and monitors visitor numbers and location data, to your website. So Google Analytics in this respect is somebody who provides you with data, with personal data. Yeah. And then you have this kind of personal data. Yes, but you have to basically list Google Analytics as a third party from which you collect this kind of personal data. And the purpose for using that data is basically finding out more about to improve your website for commercial interest, because people have certainly not given you particular consent to use that data in this way. Because everybody who clicks on a website will be potentially leaving a trace. And I think this is also part of, I don't know how Google does that, but it might use cookies. And that means that you also have to list this as a cookie on your cookie policy. So this kind of, this data protection, is also linked to the cookie policy. And the cookie policy is basically regulated by PECR again, which is old already. So for cookies, you also, you can see this little banners that are popping up on website when you visit a website for the first time, which also says, can you opt in? This is basically, yes, this site uses cookies. Please be aware of it and click here that you accept that we use, this kind of data. So I think Google Analytics, if I'm not a technical expert, but I guess Google Analytics uses some sort of cookies to analyze who is visiting the website and how, where you click on and this kind of information.
Yeah. So do you think we need to be putting banners on our websites now then about saying what, that you accept that there's cookies on our websites? Or?
Ideally, yes. Yeah, ideally, yes. And you see it more, more frequently. So ideally, you should actually give people an option to accept, that your site uses cookies and list all the various cookies they're using. So I don't know where you get this information, but this is an ideal, situation. You can always look at other people's website and how they set out the privacy policy and then have a look, what's there and how you set it out and what kind of information you should provide people with.
Yeah, I think there's like a lot of stuff going around at the moment and like popping up. So it's kind of doing a bit of research and keeping your eyes open as well is probably a good thing to do in terms of this kind of thing. So I just wanted to make it clear. So about, I think the main things that we've covered are like, if you have kind of a spreadsheet for your clients, maybe you have like a newsletter, a sign up form on your site, things like that. So like if you have, like a spreadsheet of your clients, my understanding is that there isn't necessarily something that we need to do right now for that. That's kind of okay to keep that data. But is it something that we would need to list on our website? Because it's kind of not to do with our portfolios as such. It's about people who contact you. Or do you think just keeping it that way is okay?
So if you publish a privacy policy, you should list what kind of data you have and you collect and control. Yeah. So, and then, it's like a little table. So the first column might be, for what purpose you're processing data. So think about why you are having this data and then think about what kind of data you are processing for that purpose. And then you think about the legal basis for processing, and that could include consent or a legitimate interest of your business. And then you should also have another column with, how long do you keep that data for? And then you should just think about, do you delete it at one point? And what would be a reasonable time frame for keeping that data? So that's kind of common sense. Yeah. Yes, you basically, as soon as you have personal data, and that includes work email addresses that, belong to an individual or, can identify an individual through their work email address. And doesn't matter, for GDPR, you have to treat it like personal data.
Okay, so my spreadsheet, even though it's like separate from my website, I would just put that in my privacy policy as like, I keep my clients' data so that I can, contact them when I'm free for work or whatever
you can just say, for self-promotion or something, for promotional purposes. Yeah, exactly. That's what you should do. Even if it has nothing to do with your website. Yeah. Also, you will probably have maybe a sign up on your website when people, if people can sign up on your website to your newsletter, and that might be clients, it might be public, or might be, other motion designers who want to know what you're doing. So, yeah.
Yeah. That makes sense.
So, you will have a mix of different data. Some of them are companies and some of them might be individuals.
Yeah. So on the sign up form, do you have to have like a tick box now that says like, this is so that I can send you a newsletter?
Yes.
Or, something that, and it can't be previously ticked by you. It has to be ticked by them. That's correct, right?
Yes, yeah. So you can't have pre-ticked boxes and for opt-out. No, you have to have an active opt-in for this kind of emailing. Yeah, if you have a newsletter, and you should also specify for what purpose you are processing that data. So for a newsletter, you clearly say, I will use your email address to email you, ideally even how frequent, monthly update about what I'm doing or something like that.
Yeah, that makes sense. So we need to, because I know a lot of the forms now at the moment, many people don't have that. They just kind of have first name, email address, submit or whatever. Exactly. So we need to add that. But I think that MailChimp for sure is starting to bring out like different tools and stuff to make it easier for people to add those kind of things. And
yes, but in terms of MailChimp, I've heard yesterday telling me somebody that MailChimp encourages people to send this opt-in email out, where people, using your old mailing list and then encouraging them to opt in again. So, as I said, we don't think this is necessary. Yeah, so you should just say, once you have updated and maybe the data audit and put in, your processes and updated your privacy policy, what I suggest is just in the next newsletter say, in the light of the new GDPR, we have basically done our data audit and updated our privacy policy, and just make them aware of the right to withdraw consent for, if you don't want us to process your data, you can unsubscribe from this newsletter or contact me if you have any concerns. Something like that.
Yeah, okay.
So make it easy for people. So, for example, you should also list in your privacy policy, that's good practice, all the rights they have. As a good tip, I would say, look at, I'm not sure if everybody has heard of that, but there is a body, a government agency that deals with data protection in the UK, and that's the Information Commissioner's Office. Basically, everybody, any data controller, and most of you are data controller, should actually register with the ICO. Also, the system will change from the 25th of May, but we are not quite sure how it will change. Apparently, registration is not necessary anymore. At the moment, it is obligatory to register with the ICO. Many people have not even heard of the ICO. I think at the moment it's probably for small business like you or sole traders that process very specific data, because it's very unlikely that somebody will complain to the ICO that you will be fined. But if it happens, then obviously you might be liable for a fine if you're not registered. But the ICO is also a very, very good source for information about the new legislation. It has loads of guidance on the website. So if you want to know a bit more, then you should actually visit the ICO's website. I can give you the website or you can just Google Information Commissioner's Office UK. And the website is ico.org.uk. And that is the body that basically oversees the data protection on behalf of the government and finds people, investigates people, mainly big corporations that don't comply with GDPR and might not comply with PECA. Yeah, that also falls under their remit. And big companies can be liable for big fines, and any member of the public can complain about your conduct to the ICO. So you should encourage them to complain to you first before they contact, the ICO. So this should be encouraged in your privacy policy as well. For example, that they contact you for any complaints.
Yeah, and we'll put all the links in the show notes as well for everyone. So to do some further reading and stuff like that, because I think it's definitely needed. But I think it's really, really helpful to just talk about these things and kind of let people listen into that, because then obviously most of our issues as motion designers is probably going to be quite similar. So I think it's really, really helpful.
Yeah, and in my opinion, it's always a matter of risk assessment as well. So if you're not ready by the 25th of May, I wouldn't worry too much about it because there will be many people who might not be ready. At the moment, we don't even know how, some of the regulation will be interpreted. So, there is first, we are waiting for some precedents in the courts. If something comes in the court, or the experience of people when they complain, for example, to the ICO. So they update their information and guidance also, depending on what they face, non-compliance and how people do that. So I think you can only do things to the best of your abilities. And the only, takeaway from my side is first, don't worry too much about your current existing database, as long as you give them clear guidance on how they can unsubscribe. That should be fine. Be specific about how you and what kind of data for what purposes you collect from people, how you transfer data to third parties, and also just do the data audit and update your privacy policy and publish that on your website if you can. And just be aware. I think it's more about being aware than being fearful of that.
Yeah, I think that's really great advice. Hopefully everyone will get a lot out of this episode and be a little bit more informed, which I think is the main thing. And, like you say, kind of try your best to do a bit of research and think about these things, but don't obviously get too scared and worried about it, which I think is really, really good advice. So thanks so much for coming on the show again, Silvia. It's really, really nice to talk to you.
Yeah, thank you for inviting me. So I just hope it's useful, to everybody, because it can be quite confusing. So hopefully I haven't confused people even further.
Thanks again to Silvia for coming on the show. I really appreciate it. She gave us so much knowledge, but I do encourage you to go to the ICO's website and do further research. You can find that website at motionhatch.com/17 in the show notes. If you found this episode helpful, why not share it with a friend? You can also give us any feedback over on Instagram or Twitter at MotionHatch, or you can send us an email at hello@motionhatch.com. I always like hearing from everyone. Let us know if you enjoyed the episode. Let us know if you think we could do anything better, or if you have any suggestions for the show. I'd love to hear from you. I hope you enjoyed this episode and it was helpful for you. I appreciate you all. Have a great week.